So your child's injury lawyer calls you up and says, hey, we've got to do a court approval hearing on your child's injury case. What does that mean? Would you like to know more? Well, come join me as we talk about the intricacies and ins and outs of a child injury case and why it needs to get court approval. And I thought we could do it in a little walk and talk section here in the beautiful Bay of San Diego. Okay, child settlements in California. What's this all about? Well, if you have a minor child that gets into an accident or collision, there goes a plane right by the airport, and they get a settlement and the dollar amount is a penny over $5,000, then it's required by the courts to approve that settlement for the best interest of the child. It actually is part of the California law, comes from the California Probate Code Section 3611, Section D. You can look it up. Also Section 3401. And what it says is that if there's any dollar amount that goes over $5,000 to a child for an injury case, then it has to have court approval, judge approval in a court, in a hearing. And it's all done to safeguard the interests of the child against any unfair advantage from any unscrupulous parents or family members. So it's a good thing, and there's a reason for it, and that's the logic. So what'll happen is, for example, if I have a child injury case and it's over $5,000, gross settlement, it's not the net to the child, it's actually the gross settlement amount. If it's a $5,000 or more, then I've got to petition the judge to get it approved. And how I do that is I file paperwork with the court, and I have to file it with what's called a Guardian Ad Litem. The Guardian Ad Litem is the person on the case that's going to be responsible for communicating to the child when they're older that they have this settlement and they're deposited in a certain bank, or if it's in a structured annuity. I'll touch upon that in a moment. So I usually have the mother, father, aunt, sister, or uncle, but the law says anyone over 18 years of age can be the guardian for a child settlement in California. Sometimes we have military families here and it's hard to get a family member, so we'll have to appoint some other person. But again, as long as they're over 18 years of age and they're not connected financially with the case, meaning that they're not getting a settlement. For example, I had a case where mother and child were in the same car crash, and of course mother gets a settlement, so I can't appoint her as the guardian for the child because that's a conflict of interest. She's getting an interest in the case. So we'll have the father, sister, brother, and uncle. We'll go through that list and see who we can appoint, who's going to be the best pick for that. So once that's all filed with the court, there's a hearing date set. Now with COVID, that's changed because now all the hearings are being done telephonically for structured settlement. For minor child settlement, court settlements. But before, and of course that might change in 2021, we'll go back to hearings. But before COVID, we were doing this all in private chambers with the judge, and so there's three functions of the judge in a court hearing approving a minor child settlement case. Number one is to officially appoint the Guardian Ad Litem, which we already talked about. Number two, the judge's role is to make sure that the settlement is fair to the child, okay? Meaning that the value is where it should be. There's no more funds to go after. It's all equitable and fair to the child. That's number one. The second thing that the judge does after he appoints the guardian. And then number three, he or she has to make sure that the money goes directly to the child when they become age of majority or 18 years of age, and they have to prove all that. In addition, while they're doing those three main goals, they're approving the attorney's fees for the case, the attorney's costs for the case, and I get a lot of questions on that. The fees for the case is generally 25%, meaning that the contingency fee can't go over 25%, but that's not entirely correct. A lawyer can charge more than 25%, 33, 36% if there was special legal talent or skills involved in a case to get a case accomplished to get a settlement. But that still has to be approved by the judge. Normally what I do is I just charge the 25% because I want to maximize the child's recovery, whether or not it goes into a bank account until they're 18 or structured annuity. So the judge approves the fees and costs of the attorney, the judge approves the guardian, the judge makes sure that the settlement is fair and equitable to the child, and the judge approves or makes sure that the child gets the settlement funds when they turn 18, or if it's a structured annuity, when they get that. So the judge also approves any structured annuity, and we'll talk about that right now. So there's two ways that you can deposit funds, generally speaking, in a child minor injury case. That is either in a blocked account until they're 18 in a bank, or it's in a structured annuity, which is actually an insurance contract with an insurance company to guarantee lump sum payments through time. So if it's a structure, there's certain parameters that we have to use to employ an annuity. Number one is the amount of the settlement. So we want the settlement to be, usually the structured annuity is for a larger case, so we want the settlement to be a certain dollar amount, and we also want the child to be a little bit younger because there's more time for that structured annuity to really grow and be a really big benefit for the child. So for example, if there's a case and there's $150,000 that needs to go to the child, then that's a great example of using a structured annuity, and the parents can select plans. I'm not a financial advisor. I employ an independent firm to do these estimates, and again, it is judge approved at the hearing, but it's something that the parents can look at, because a lot of times you don't want a whole bunch of money going to a child when they turn 18 years of age. And having a structured annuity in that example is a great way to balance the interests of the child's responsibility as they grow. So for example, there could be a certain lump sum when they're 18, another lump sum when they're 19, 20, 22, 24 years of age. It's a great way to manage the money, and the longer you have it structured, of course, the better the return, because you have that time element for the child. So you might be wondering and asking yourself, well, why am I sharing you this valuable information? Well, you might be having a question or two about child injury settlements. Perhaps you were offered a settlement from an insurance company and you're hearing chatter about having to have this approved by a judge. So yeah, in those cases, you can always give me a call. I'm more than happy to help people when they have questions on child injury cases here in San Diego. My phone number is 619-813-7955, and you can find me also on the email, mark@blanelaw.com. And I hope you found this information very useful, and you can use this in your injury case for your child if they're in a situation where they're facing a settlement. All right, so that's it for the video, and have a great day. Thank you. Hey guys, I hope you enjoyed that video on child injuries in California and how they're unique and different and have special rules. And I realize that they can be complicated, which is one of the reasons why I made this video. But I do have free resources for parents and family members of injured children that are really valuable and can answer a lot of your questions. The first one is Justice for the Injured Child. It's a free ebook download on my website at www.blanelaw.com. You can grab a free copy anytime. Also, I've got How to Prevent, Discover, and Act on Claims of Daycare and Child Care Abuse in California. Another valuable resource for any parent that might have questions about abuse claims in California and the legal process that applies. So again, the information is completely free on my website. I hope you found this really useful. I'm going to be doing a lot more videos on child injuries, the special rules, and how to navigate these cases because they are unique. And so stay tuned for that. And have yourself a wonderful and great day, and thanks for watching. Be strong. Bye-bye.
Life that makes life possible. To the gravity that glues us to an Earth that would otherwise send us spinning off into space. Or to the atoms of which we're made and on whose stability we fundamentally depend.